Welcome to the second episode of Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin Gregg, an immigration attorney with the law firm Kurzban, Tetzeli & Pratt, back again to discuss the week's presidential immigration cases, provide practical insights, and rummage through the decisions so you don't have to. I hope you caught last week's opening episode. If you didn't, give it a listen. Tell me what you think. Maybe even rate us. As always, this show does not constitute legal advice and has no bias other than to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. To quote the Backstreet Boys, oh my god, we're back again. Episode 2 of Immigration Review. We have a great show lined up for you, covering all 7 immigration cases published this week. We address the categorical approach, modified categorical approach, CIMTs, divisibility, and more, and even include some wise words from RBG herself. Let's get to the first case. Let's jump into our first in-depth case of the day, Mero v. Barr, out of the Ninth Circuit on May 1st, 2020. In this case, the Ninth Circuit granted in part Mr. Mero's petition for a review of a decision of the Board of Immigration Appeals finding him removable, and the Ninth Circuit held that Mr. Mero's conviction for, quote, possession of visual presentation depicting sexual conduct of person under 16 years of age, end quote, in violation of Nevada Statute 200.730 is not a sexual abuse of a minor aggravated felony as defined at INA Section 101A43A. Bit of a mouthful. This case concerns aggravated felonies at immigration law and the categorical approach analysis, which just so happens to be my favorite part of immigration law. It's also one of the most complicated areas of immigration law, and it was bound to come up eventually. Turning first to the facts and procedural history. Mr. Mero was convicted under Nevada Statute 200.730, which criminalizes, again, quote, possession of visual presentation depicting sexual conduct of person under 16 years of age, essentially possessing child pornography. Although the case doesn't say it, Mr. Mero is likely a lawful permanent resident, and LPRs are removable from the United States and lose their green card if they are convicted of an aggravated felony. Now, depending on how you're counting, immigration law has about 30 aggravated felony definitions. One of those is INA Section 101A43A, sexual abuse of a minor. DHS charged Mr. Mero as removable because it alleged that his Nevada conviction was a 101A43A sexual abuse of a minor aggravated felony, and both the immigration judge and the BIA agreed. Now for the holding. The Ninth Circuit disagreed and held that Nevada Statute 200.730 is not a sexual abuse of a minor aggravated felony under INA 101A43A. Why, you may ask? By applying what's known as the categorical approach. To try and address a very complicated topic briefly, the categorical approach analysis is a legal analysis mandated by the Supreme Court and all circuit courts of appeals. It applies to criminal conviction analysis at immigration law and in other contexts, such as determining sentence enhancements under the Armed Career Criminal Act, or ACCA. So immigration practitioners often rely upon ACCA case law, and vice versa. The categorical approach is a way for courts to determine the effect of past criminal conduct without engaging in a second mini-trial. So, for example, in the case of Mr. Mero, courts are not really interested in what Mr. Mero did. He's already been found guilty under Nevada Statute 200.730, and he served his criminal sentence. Rather, immigration courts in the Ninth Circuit are legally concerned only with the minimum amount of conduct for which Mr. Mero could be found guilty of violating Nevada Statute 200.730. Because again, the immigration court is not holding a mini-trial about what Mr. Mero actually did. This is where the categorical approach comes in. In essence, the categorical approach requires a court to compare the legal elements of the criminal conviction, in this case, Nevada Statute 200.730, with the legal elements of the ground of removability, in this case, the sexual abuse of a minor aggravated felony under INA Section 101A43A. If the elements of the criminal statute are broader, i.e., encompass more criminal conduct than the removability statute, then the criminal statute is not what we call a categorical match to the removable offense. In other words, we're trying to determine whether the Nevada criminal statute matches the federal definition of a sexual abuse of a minor. How do we determine the elements of the criminal offense, the Nevada statute in this case? Well, first, we look to the statutory text, as the Ninth Circuit did in this case. If the text does not resolve the issue, courts look to jury instructions, state Supreme Court case law, and sometimes state appellate court case law to define the crime's elements. In this case, the Ninth Circuit looked to the Nevada statute text itself and noted that the statute criminalized someone who essentially possessed child pornography. So that's the criminal statute. What about the elements of the removability offense? In this case, the sexual abuse of a minor aggravated felony. Because remember, the criminal statute elements and the federal removability statute elements have to match. The removability statute elements are defined by Supreme Court, Circuit Court of Appeals, and BIA case law. This is a complicated endeavor, which we will surely dive into in the coming weeks with other cases. As if the analysis was not complicated enough, the Ninth Circuit applies two different elemental definitions of the sexual abuse of a minor aggravated felony, depending on the type of criminal conduct at issue. Specifically, the Ninth Circuit applies one definition for statutory rape-type crimes and another definition for other type of crimes. This case concerns the other type of crimes, and so the elements of the sexual abuse of a minor aggravated felony are 1. Sexual conduct, 2. With a minor, and 3. That constitutes abuse. So, my dear listeners, if you're still with me, you may be wondering why a conviction that criminalizes possessing pornographic material of a person under the age of 16 does not match the federal definition of sexual abuse of a minor for aggravated felony purposes. The reason, according to the Mero court, is because the Nevada statute does not require any sexual conduct at all, which is the first element of the sexual abuse of a minor aggravated felony. The Nevada statute at issue in this case does not require any contact with any person whatsoever. And because the Nevada statute never requires any sexual conduct as an element, the analysis is over. Mr. Mero's conviction under Nevada Statute 200.730 can never be a sexual abuse of a minor aggravated felony because it never has the first required element. The inquiry stops with the categorical approach, step 1. Some of you may be wondering, wait a minute, Kevin, what about the modified categorical approach? Rest assured, we will cross that bridge soon. Later in the podcast, in fact. But this case does not involve the modified categorical approach, so we'll leave that for later. Now for practical points and observations, aka the good stuff. First, just a personal aside, I know the government attorney on this case, Benjamin Moss. Even though the Ninth Circuit disagreed with him, Mr. Moss is a great lawyer and an even better person, and he deserves to be recognized on the most prestigious immigration case law podcast in existence. Personal unsponsored shout-outs aside, it's important to note that the Ninth Circuit buttressed its analysis regarding the definition of sexual conduct by looking to various federal criminal statutes. For crimmigration practitioners, it's always good strategy to survey federal and state crimes similar to the conviction your client has and compare the elements of those crimes to your client's crimes. We've seen the Supreme Court, circuit courts, and BIA conduct such surveys of criminal statutes more and more often in recent years to come up with the generic definition of removable offenses. This case also touched on another aggravated felony, albeit briefly, defined at INA Section 101A43I, an offense, quote, relating to child pornography, end quote. But as you've probably gathered by now, this is a more complicated analysis than it sounds, and the U.S. government attorneys asked the Ninth Circuit to remand proceedings back to the BIA because it seems that the U.S. government does not believe that Mr. Mero's offense matches the definition of an INA 101A43I aggravated felony either. So, the Ninth Circuit remanded proceedings back to the BIA for further analysis on that issue. It could make your head spin, I know. Hopefully yours is not. And so, let's move on to the next case. Next on deck, another case out of the Ninth Circuit, Romero-Millan et al. V. Barr, published on May 4th, 2020. So this is a bit of a weird one. In this case, the Ninth Circuit did not remand proceedings or find any error in the BIA's analysis. Rather, the Ninth Circuit certified 3 questions to the Arizona Supreme Court, all relating to the divisibility of 2 Arizona drug crimes. If you're wondering why the Ninth Circuit didn't just answer these questions itself, the answer is the categorical approach. Returning to that in a bit. Let's get to the facts and the law. This case actually involves 3 separate cases, all consolidated together before the Ninth Circuit. And the facts aren't all that important. All you need to know is that in one of the cases, the non-citizen was convicted of possessing or using drug paraphernalia in violation of Arizona Statute 13-3415. And in the other cases, the non-citizens were convicted of possessing a narcotic drug for sale in violation of Arizona Statute 13-3408A2. The Ninth Circuit is trying to decide in this case whether those convictions make non-citizens removable from the United States as convictions that violate a law, quote, relating to a controlled substance, end quote. As the Ninth Circuit explained, following the Supreme Court's decision in Mullooly v. Lynch, 575 U.S. 798, 2015, a state drug crime only relates to a controlled substance, as required at immigration law, if the state crime requires, as an element, the involvement of a drug defined at 21 U.S.C. Section 802. Section 802 is the federal government's controlled substance list. And how do courts determine whether a state drug crime requires, as an element, a controlled substance listed in Section 802? You guessed it, the categorical approach. Now we're all now familiar with Step 1 of the categorical approach, based on the discussion we just had in Mero v. Barr. But in Mero, the analysis stopped at Step 1, because the statute in that case could never match the removable offense. And so the court didn't need to reach the second step of the categorical approach, divisibility. But in this case, we do. A statute is divisible if it lists one or more elements of the offense in the alternative, as opposed to listing alternative means of committing the crime. Put another way, the question is, does the statute list a bunch of subcrimes, making it divisible, or does it just describe one crime that can be committed in many different ways, making it indivisible? In the Ninth Circuit, a state statute contains alternative elements if a jury must unanimously agree how, out of multiple possibilities, a defendant committed the crime. That statute is then divisible. Alternatively, if a jury can find a defendant guilty of a crime but not agree on how he committed that crime, the statute is not divisible. Now, most state drug crimes do not categorically match the federal drug list at Section 802. Most states criminalize more drugs than the federal list, and both lists are always changing. Accordingly, because the states criminalize more drugs than the feds, most state drug crimes are broader than the federal drug definition, which means that most state drug crimes are not categorical matches to the federal drug offenses at immigration law. Many state drug crimes, however, are divisible as to the specific drug at issue. But some are not. For example, if a statute criminalized, say, possessing any drug without requiring the prosecution to prove the specific type of drug, the statute would not be divisible as to the drug, and a non-citizen would almost surely not be removable for having been convicted of that offense. In this case, the Ninth Circuit is unsure whether the two Arizona statutes are divisible as to the drug. That is, the Ninth Circuit does not know whether a prosecutor in Arizona must prove the specific type of drug a defendant possessed. The Ninth Circuit was not able to answer the question solely by looking to the criminal statute's text. The next place to look would be Arizona Supreme Court case law, but the Arizona Supreme Court hasn't answered the question, and both the non-citizens' attorneys and the government attorneys cited to cases and authority that support both divisibility and non-divisibility. So, unsure of the answer, the Ninth Circuit certified the question to the Arizona Supreme Court for final answer. One little quirk of the law, the Arizona Supreme Court can actually reject the Ninth Circuit's request if it wants to, but I doubt they will. And that's the holding of the case. Arizona Supreme Court, please help us. And that is Romero-Millan v. Barr. We're going to just continue with the Ninth Circuit and finish up with their published decisions this week, and move on to Aguilar Fermin v. Barr, published by the Ninth Circuit on May 5th, 2020. This is a case about asylum and jurisdiction. It also has some interesting facts. Miss Aguilar fled to the United States from Mexico because her brother-in-law, a former Mexican soldier, refused the demands of a gang. The gang threatened to kill his family, and so he, Miss Aguilar, and her minor son fled to another part of Mexico. But Miss Aguilar continued to receive threats related to her brother-in-law from the gangs. Miss Aguilar reported one such threat to the police, who made no arrests. Eventually, Miss Aguilar and her son fled to the United States. Shortly after arriving in the United States, Miss Aguilar was served with a notice to appear, known as an NTA, the charging document in immigration court, which didn't have the date, time, and location of her first removal hearing as required by INA Section 239A. That information, however, was eventually provided to Miss Aguilar in a notice of hearing, and Miss Aguilar appeared for her hearings. I think some of you know where this is going. An IJ found Miss Aguilar removable because she did not have a legal document to remain in the United States, and she applied for asylum, withholding of removal, and protection under the Torture Convention. If successful, these forms of relief would allow Miss Aguilar to remain in the United States even though she didn't have documents to enter the United States initially. The immigration judge found Miss Aguilar not credible based on inconsistencies and implausibilities, and so he did not believe her story of what happened to her in Mexico. For this reason and for alternative reasons, he denied her asylum and withholding claims, and he also denied her Torture Convention claims. She appealed to the Board of Immigration Appeals, and the board dismissed her appeal. But a couple of months later, the Supreme Court of the United States published the case Pereira v. Sessions, 138 Supreme Court 2105, 2018. That case addressed a provision of the stop time rule, applicable to a form of relief called cancellation of removal. If you want to learn even more about the stop time rule, I urge you to listen to the discussion of Barton v. Barr in last week's immigration review. In reaching its holding in Pereira, the Supreme Court stated that a notice to appear that, quote, fails to designate the specific time or place of the non-citizen's removal proceeding is not a notice to appear under INA Section 239A, end quote. Relying on that language and the Supreme Court's rationale in Pereira, Ms. Aguilar filed a motion to reopen with the Board of Immigration Appeals, arguing that the immigration judge lacked jurisdiction over her removal proceedings due to the deficiency in the notice to appear. Specifically, it was missing the date, time, and location of her first removal hearing. The BIA rejected this nearly identical argument in matter of Bermuda's Coda 27 I&N Decision 441, BIA 2018, finding jurisdiction satisfied before the IJ so long as a notice of hearing is later sent with the date and time of the non-citizen's immigration court hearing. Relying on Bermuda's Coda, the BIA denied Ms. Aguilar's motion to reopen. Ms. Aguilar appealed everything to the Ninth Circuit. And the Ninth Circuit upheld the asylum, withholding, and torture convention findings by the BIA under the deferential standard of review. Moving to the jurisdiction-based motion to reopen, the Ninth Circuit, like the majority of circuits to have already addressed this issue, read Pereira narrowly as discussing only the requirements of the stop time rule for cancellation of removal, holding that, quote, the Supreme Court did not address the requirements for an NTA to vest an immigration court with jurisdiction, end quote. So that's the holding. Ms. Aguilar is wrong. The immigration judge had jurisdiction over her removal proceedings, and she is ineligible for asylum, withholding of removal, and torture convention protection. Now for some practice pointers and observations, aka the good stuff. Turning back to jurisdiction, the Ninth Circuit made this nearly identical holding last year in Karagithi v. Whitaker, 913 Fed 3rd 1158. The only difference between Karagithi and Ms. Aguilar's case, and possibly the only reason the Ninth decided to publish this case, was that Ms. Aguilar's NTA was missing the date, time, and location of her first immigration hearing, whereas the NTA in Karagithi was only missing the date and time. Fascinating, I know. After Karagithi was issued, the BIA addressed the issue in matter of Rosales-Vargas, 27 I&A Decision 745, BIA 2020, and held that an NTA missing the address is no different than an NTA missing the date and time of the first hearing. An IJ has jurisdiction regardless. In this case, the Ninth Circuit is agreeing with Rosales-Vargas. One last point about NTAs and jurisdiction. All circuit courts to review this issue have now held that an NTA that does not comply with INA Section 239A and the applicable regulations is jurisdictionally insignificant. Immigration courts acquire jurisdiction once DHS files an NTA with the immigration court, even if the NTA does not comply with INA 239A. However, the circuits have differed in how they get to this point. Some circuits, including the 7th and the 11th circuits, have held that the regulations governing NTAs implement a mandatory claims processing rule that DHS and the immigration courts, as agencies, must follow. Like with all claims processing rules, if DHS does not comply with the mandatory rule governing NTAs, and if a non-citizen timely asserts the rule, an immigration court arguably has grounds to dismiss the immigration case. So know your circuit and assert your claims processing rules. Finally, turning back to the asylum portion of this decision. In upholding the adverse credibility finding, the Ninth Circuit does state, consistent with its prior precedent and that of the Second Circuit, that Ms. Aguilar was properly, quote, given an opportunity to explain the inconsistencies and implausibilities in her testimony. Therefore, the logic goes, had the IJ not identified the inconsistencies and not allowed Ms. Aguilar an opportunity to explain, the adverse credibility finding very well may have been overturned. This opportunity to explain requirement is subject to a bit of a circuit split, and just precisely what satisfies this standard seems to be somewhat of a moving target. So stay tuned. And that is Aguilar Fermin v. Barr. Next up is our first case out of the Board of Immigration Appeals, matter of Herrera-Vasquez, 27 I&N Decision 825, BIA 2020. In this case, the Board of Immigration Appeals held that the absence of a checked alien classification box on an NTA does not, by itself, render a notice to appear fatally deficient or otherwise divest an immigration judge of jurisdiction over removal proceedings. And it is therefore not a basis to terminate the proceedings of an alien who has been returned to Mexico under the Migrant Protection Protocols. This is another NTA jurisdiction case, based in part on arguments that stem from the Supreme Court's case in Pereira v. Sessions. The case is similar to the Ninth Circuit case Aguilar Fermin v. Barr, which we just discussed. and it's consistent with what is becoming a long line of recent BIA cases, including matter of Bermuda's Coda, matter of J.J. Rodriguez, matter of Rosales, and others. This case also involves the new Migrant Protection Protocols, or MPP, also known as the Remain in Mexico policy. Facts first. The respondent is allegedly from Honduras and entered the United States without authorization from Mexico. He was discovered shortly after entering the U.S. and served with an NTA. There are 3 boxes at the top of any NTA, and with these boxes, DHS must identify whether a non-citizen is either 1, an arriving alien, 2, present without admission or parole, or 3, admitted to the United States but otherwise removable. Each of these classifications brings with it different legal consequences in removal proceedings. But in this case, DHS did not check any of the boxes and returned the non-citizen to Mexico to await his removal hearing pursuant to the MPP program. When his first hearing arrived the next month, the respondent did not return to the United States from Mexico for his hearing. DHS moved the immigration judge to order the non-citizen removed in absentia. The IJ denied that motion and terminated proceedings for DHS's failure to designate an appropriate category classification in the NTA. The BIA reversed and held that jurisdictionally, it does not matter whether or not DHS checks a classification box on an NTA. Relatedly, the BIA held that DHS's failure to classify a non-citizen does not provide an IJ grounds to terminate proceedings. Not much good for non-citizens in this one. The BIA's decision is kind of written in a vacuum and does not account for any of the difficulties IJs and non-citizens are dealing with due to the MPP. Based on this decision, a non-citizen does not have grounds to terminate his removal proceedings, even if DHS does not comply with the first requirement of the NTA, designating the non-citizen's classification. With this decision, and many decisions like it over the last 2 years, the BIA appears to be dulling the importance of the regulations and preventing non-citizens from asserting claims in immigration court based on DHS's regulatory violations or mistakes. The BIA's decision also follows a recent trend begun in 2018 by then Attorney General Sessions in matter of Castro-Tum and matter of SOG and FDB, of placing expansive authority with DHS and limiting the authority of IJs to terminate proceedings or take other judicial action unless the action is explicitly stated in the Immigration and Nationality Act or the regulations. One note for Respondents' Counsel, though. In footnote 5 of the decision, the BIA does recognize that because the regulations relating to the initiation of removal proceedings are claims processing rules, a non-citizen who timely asserts a deficiency in the NTA and shows that he suffered prejudice may present grounds for dismissing removal proceedings. But that case has not come up yet. And that is matter of Herrera-Vasquez. Next up, we're going to look at a Supreme Court case, United States v. Sineneng-Smith, published on May 7th, 2020. This is not an immigration case per se, but it definitely impacts immigration practitioners. And of course, it's the Supreme Court. So I thought I'd discuss it briefly. This is a unanimous decision issued by the notorious RBG, aka Justice Ginsburg. This case regards criminal liability under 8 U.S.C. Section 1324. Which makes it a federal felony crime to, quote, encourage or induce an alien to come, to enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming, entering, or residence is or will be in violation of the law, end quote. The conviction carries with it an enhanced penalty if, quote, done for the purpose of commercial advantage or private financial gain, end quote. So without getting too deep into the facts of this case, a non-attorney was convicted of violating this statute for filing a bunch of fraudulent labor certifications. Before the district court, she challenged the constitutionality of the statute, and the district court dismissed her arguments. Before the Ninth Circuit, with the assistance of amicus counsel, she made somewhat of a different argument, and the Ninth Circuit vacated her conviction and found the statute unconstitutional under the overbreadth doctrine, whereby a statute can be invalidated if, quote, a substantial number of the applications are unconstitutional, end quote. This is similar to the void for vagueness doctrine applied by the Supreme Court in Johnson v. United States and Amaya v. Sessions, 138 Supreme Court, 1204, 2018. So now the statute is back before the Ninth Circuit to consider the arguments that were raised by the parties. One important note for immigration practitioners: we all need to follow what happens with this case on remand. Even though it appears that Ms. Sineneng-Smith was acting unethically, the Supreme Court does not appear to have a problem with the District Court's reasoning that Ms. Sineneng-Smith was guilty of criminal conduct because, by filing fraudulent labor certifications, she was, quote, encouraging non-citizens to remain in the country, end quote. Taken to a logical conclusion, and taking out the fraud component, such a criminal statute could make illegal what immigration practitioners do every day. Not time to freak out yet, but keep an eye on this case, as I know many of you are doing. There is an interesting quote from the Supreme Court in this case that immigration practitioners can use. In vacating the Ninth Circuit's decision, the Supreme Court begins its analysis by stating, quote, in our adversarial system of adjudication, we follow the principle of party presentation in both civil and criminal cases, in the first instance and on appeal. We rely on the parties to frame the issues for decision and to assign to courts the role of neutral arbiter of matters the parties present. Let me repeat and paraphrase that a bit. In both civil and criminal cases, judges are bound by the issues as framed by the parties, and the judge is relegated to the role of neutral arbiter. One can envision a quote like this assisting immigration practitioners on appeal to the board. And finally, for those of you taking a long view of Supreme Court jurisprudence, Justice Thomas in concurrence would like to consider doing away with the overbreadth doctrine altogether. So keep your eye on that. And that was United States v. Sineneng-Smith. Moving right along to the Fourth Circuit Court of Appeals, to Cucalon v. Barr, published on May 7th, 2020. This case is similar to the Ninth Circuit case we discussed earlier in the podcast, Romero-Millan v. Barr, so we're going to focus really just on the holding. Mr. Cucalon was convicted under Virginia Code Section 18.2-248D, distribution of cocaine as an accommodation. The Fourth Circuit in this case held that the Virginia statute is divisible as to the controlled substance at issue, and, applying the modified categorical approach, that Mr. Cucalon's conviction makes him removable for having been convicted of a drug trafficking aggravated felony, as defined at INA Section 101A43B, and additionally for having violated a law relating to a controlled substance under INA Section 237A2BI. And that's the holding. Now, had the Fourth Circuit found that the statute is not divisible, the holding would have likely been different, and Mr. Cucalon would not likely have been removable. This is because, similar to the question presented in Romero v. Barr, both removability provisions at issue in this case incorporate the federal controlled substance list, 21 U.S.C. Section 802, and Virginia's controlled substance list, like that of most states, is broader than Section 802 because it covers more drugs. Both lists, however, include cocaine. Because the Fourth Circuit found the statute divisible as to the controlled substance at issue, it went on to review what we call the Shepard documents, named after a 1990s Supreme Court case, and determined that Mr. Cucalon's crime involved cocaine. The Shepard documents included Mr. Cucalon's charging document, plea agreement, plea colloquy, and any jury instructions that were given. Because the Shepard documents showed that the conviction involved cocaine as an element, the Fourth Circuit found Mr. Cucalon removable under both controlled substance removability grounds. And that's about it for the holding of this case. Here's some quick notes. The reason the Fourth Circuit could answer the divisibility question in this case, but the Ninth Circuit could not answer the question in Romero, is because the Fourth Circuit concluded that the Virginia Supreme Court had previously held that Virginia Section 18.2-248 requires, as an element, proof of the type of controlled substance. Also interestingly, in footnote 3, the Fourth Circuit recognizes that the BIA applied the categorical approach incorrectly in this case, and that's usually a cause for remand. But, because the divisibility of a criminal statute is a pure question of law, the Fourth Circuit answered it without remanding for the BIA to do any other analysis. Finally, a somewhat academic note. As you may recall, the statute in this case criminalizes, quote, accommodation, end quote. According to the Fourth Circuit, an individual can commit an accommodation offense even if, say, he distributes cocaine without any intent to profit financially. But without an intent to profit financially, a criminal offense may not qualify as an aggravated felony drug trafficking crime. The Fourth Circuit nevertheless held that the statute in this case is a drug trafficking aggravated felony because, under Virginia law, the sole effect of the use of the word accommodation is to establish a partial affirmative defense where a defendant did not intend to profit. The word accommodation, according to the Fourth Circuit, is not an element of the crime itself. And with that, we have the unfavorable decision, Cucalon v. Barr. Our final case on the podcast this week is out of the Eighth Circuit, Bakor v. Barr, number 183011, published on May 7th, 2020. This is the podcast's first crime involving moral turpitude case, also known as a CIMT. Hold on to your headphones, listeners. You're in for a reprehensible ride. Mr. Bakor is an LPR. An LPR is removable from the United States under INA Section 237A2A if he has been, quote, convicted of 2 or more crimes involving moral turpitude, not arising out of a single scheme of criminal misconduct, end quote. In 2001, Mr. Bakor was convicted of criminal sexual conduct in the 5th degree under Minnesota Statute 609.3451, Subdivision 1. This, in turn, required that he register as a sex offender, which he failed to do in 2015, for which he was convicted under Minnesota Statute 243.166, Subdivision 5A. An IJ determined that both convictions are CIMTs, and that Mr. Bakor is therefore removable, and the BIA agreed. So, CIMTs. A relic of another age, when homosexual conduct was considered morally turpitudinous. Over the years, both society and the CIMT definition have evolved, an evolution that seems to change ever so slightly with each new decision out of the courts. The Supreme Court and the circuit courts have found the term constitutional, including in recent years. The proverbial cockroach of immigration law, CIMTs appear destined to stick around forever. But what is a CIMT? The federal immigration definition is slightly different in each circuit and at the BIA. In the Eighth Circuit, like in all circuits really, it requires at a minimum, quote, reprehensible conduct and a culpable mental state. And because the term CIMT is ambiguous, the circuit courts of appeals must defer to the BIA's CIMT case law if the BIA's decision satisfies the Chevron case out of the Supreme Court in 1984. Don't worry, folks, we're not diving into Chevron deference today. Just want to throw it out there, though, kind of as a nerdy teaser for podcasts to come. Turning back to this case, to determine whether a state conviction matches the CIMT definition at immigration law, we apply the categorical approach. Applying step 1 of the categorical approach in this case, the Eighth Circuit held that both of Mr. Bakor's convictions match the CIMT definition. He is therefore removable for having been convicted of 2 CIMTs. And here's why. Addressing the first conviction, criminal sexual conduct in the 5th degree, The Eighth Circuit held that it involves reprehensible conduct because conviction always requires non-consensual sexual contact. This, according to the Eighth Circuit, distinguished Mr. Bakor's conviction from the BIA's 2013 decision, matter of Cortes Medina, 26 I&N Decision 79. Addressing Mr. Bakor's 2015 conviction for failure to register as a sex offender, the Eighth Circuit first held that failure to register in Minnesota is turpitudinous because it requires a culpable mental state. The defendant must knowingly fail to register. Second, the Eighth Circuit found that violation of the registration requirement is morally reprehensible because the registration requirement is, quote, designed to protect vulnerable victims against recidivist sex offenders. In so holding, the Eighth Circuit deferred to the BIA's decision, matter of Tobar Lobo, 24 I&N Decision 143, BIA 2007. And that's the holding. Now some notes. First, whether matter of Tobar Lobo is good law is subject to a circuit split. As the Eighth Circuit notes in this case, the Ninth, Third, and Fourth Circuits have criticized Tobar Lobo and declined to follow it, at least in part, due to the fact that the BIA and Tobar Lobo held that, quote, merely forgetting to register as a sex offender qualified as a CIMT, end quote. Even the Eighth Circuit doesn't go this far, and appears to defer to Tobar Lobo only to the extent that the regulatory violation at issue requires a knowing, culpable mental state, also known as mens rea. Now to really get into the weeds on this, the Third Circuit held in Totemeh v. Attorney General, 666 Fed 3rd 1009 in 2012, that failure to register as a sex offender in violation of the same Minnesota regulation is not a CIMT. That's the Third Circuit decision that declined to defer to Tobar Lobo. So there's a circuit split on the very holding of this case, the very Minnesota regulatory violation at issue in this case. And importantly, because the question is one of statutory interpretation, the Eighth Circuit's decision in this case is no more binding than that of the Third Circuit's, unless of course you're practicing in the Eighth Circuit. In fairness, the Eighth Circuit argues that the Third Circuit's holding has been superseded by a Minnesota Supreme Court case from 2017, State v. McCulloch. And that may be true, but that would require research beyond the scope of this podcast. But just reading the dissent in this case, the Third Circuit's decision in Totemeh appears to rest on another ground, unaffected by McCulloch, and in any event, the Third Circuit's decision remains good law in the Third Circuit, unless and until the Third Circuit says otherwise. What a fight! Here's another one. According to the Eighth Circuit in this case, a, quote, recklessness mens rea might sometimes suffice to make a conviction a CIMT. This too is a developing legal question, subject to a bit of a circuit split, so stay tuned. One final note. Before the BIA, Mr. Bakor's attorneys smartly urged the Board of Immigration Appeals to overturn matter of Tobar Lobo, an argument that was almost sure to fail before the BIA. But they needed to make the argument to preserve the issue for petition for review before the Eighth Circuit. Again, very smart. Now, according to the Eighth Circuit, Mr. Bakor did not exhaust some other arguments that he ultimately made on petition for review, and so the Eighth Circuit did not consider those other arguments. Dissenting Judge Kelly did, however, and she agreed with some of them. So maybe, just maybe, those arguments might result in a different outcome next time a violation of the Minnesota registration regulation is challenged. And that is Bakor v. Barr. So there you have it. I'm Kevin Gregg from the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening. I hope you enjoyed it. If you did, please share it with a friend. Rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. For questions, comments, or anything at all, email us at immigrationreviewpodcast@gmail.com. And follow us on Instagram and Facebook @Immigration Review. Or send us a tweet @ImReview. That's IMM Review. I'll be back next Monday for a brand new episode. Until then, I'm Kevin Gregg, bringing you the Immigration Review.